Morning, friends. We are going to have today lecture on contract law. This is in continuation with the 10th lecture. This lecture is on unilateral mistake, pay contract, and penalty default. As I have in the 10th lecture, we have discussed a couple of points where whether you are your contract is valid if you are really drunk, or then we also discussed the invalid contract and different other contexts also. So today, in order to continue with that, we have to understand the unilateral mistake. So we have already seen the lane law example in the earlier lecture, and there also we had seen that this wartime depressed price made somebody buy the tobacco at a very lower cost, and then the lane law firm had sued because the next day the price has gone up. So the Supreme Court of New Orleans was not required to communicate this information is what is actually the prima facie directive of the court. So unilateral mistake in that sense, it makes a kind of effort which talks about or whether if one party makes a mistake, then that is actually by how it is binding under the legal structure. So a productive versus redistributive information is what is now we are trying to deal with when we speak about a unilateral mistake. What is a productive information? In that context, a productive information is an information that can be used to produce more wealth. So it is not blatantly the court had ruled against the lane law firm because of many reasons, because we will be seeing, and under other circumstances we have also seen that the court ruled in favor of the party or the person who sued. So the court itself is having a clarity on this matter. That is, they try to make a point that unless the case is actually a productive one, that means a wealth creating one, there is no point of actually favoring in favor of that particular suit. So redistributive information, on the contrary, we mean that an information that can be used to redistribute wealth in favor of informed party. So these two distinctions are very important in the Kutra-Newland textbook when we speak about this problem of contract law. The contract based on one party's knowledge of productive information should be noticed, because especially if that knowledge was the result of an active investment. So if that is the case, then you need not to actually worry too much about it, because that itself gives an incentive to the parties who try to acquire information, try to get positive advantage over the information which they do have. So all this is in fact produces more and more information. So contract based on one party's knowledge of purely redistributive information or fortuitously acquired information should not be info. But on the contrary, if you have actually some sort of an information, then that should not act against your own interest or against your own information availability. So this is very important as far as the productive information as well as the redistributive information is concerned. And next we may discuss about other reasons a contract may not be enforced. So under such circumstances, under the productive and productive as well as the redistributive information, we need to be very careful. That is, the court itself need to be very careful to deal with such matter. So the lawyers or the legal institution itself is aware of this fact. So in that context, we will be stopping there, and let's talk about the vague contract terms, which is another set of unenforceable kind of, or should not be enforced, or it is inefficient to enforce such kind of thing. So court will generally not enforce contract terms that are overly vague. Okay, that means the vagueness comes in different format. that is can be thought of as a penalty default. So that is punish the party by refusing to enforce contract. That is what is says. So people will be more clear when they write contract. So this is why this whole clause means that is if your contract is vague, then that cannot be enforced. That cannot be enforced mean that you are going to lose, and even if you make a contract and that contract never gives you any sort of incentive in that sense. So the non-enforceability in that sense is a punishment for the contract or the person who engaged in the contract. If it is vague, then the court is not actually supposed to enforce such sort of a contract. But some exceptions also being given. For example, parties may commit to renegotiating the contract in good faith under certain contingencies. Right? We have already seen similar cases in different contexts, and let's discuss some of this. For example, now first of all we talk about the adhesion. That is shrink wrap licenses. Back when software came on disk or CDs, people were talked about boxes was wrapped in cell phones, or things are being covered in boxes, and that people may claim that should not actually contain a message which is so vague or so so unenforceably bad. But how far or how bad that is, we will be discussing. That is, suppose if you have a box comes with a mobile phone or a CD or something like that, and inside the box somebody had written, or by unwrapping this box you agree to the following terms. So it is like if you open this, then you are bound to. So something like that. So due to the unscheduled trip to the auto wrecking yard, the school bus will be out of commission for 2 weeks. Note: by reading this letter out loud, you have waived any responsibility on our part in perpetuity throughout the known universe. So this is a kind of a situation try to actually ask or kind of inform, then that is actually a piece. Really, it is not a good piece. So for example, another set of a very Mephistopheles encounter in EULA case, which is very interesting. Okay, motel, I come offering a deal. Read the sign. So by entering this room, you agree to forfeit your own soul rather than negotiate with the mortal residing there. Wait, you can't. Too late, because you have already entered in the room. So this is an interesting, if you see the movie like Ghost Rider and all, they deal with it is a very interesting contract, that talks about. So this is under the legal structure. This is very, very bizarre kind of situation. So in that contract, in the Ghost Rider, because he entered into the contract, so he has to buy everything. So it is something like that. So contract is not binding if one party had no opportunity to review it before agreeing. So the reviewing itself should not be constrained, that you don't have an option to review. Then that kind of a contract is where the devil says that your father is going to die other way, or your girlfriend is going to be hurt. Now either the way, you don't have a choice in that sense. So if that is the case, then immediately what happens, you enter that contract itself become a default contract, which is called the devil's contract. This is not actually something which we deal under the legal structure in that sense. So what if a party, that is under section 2, what if a party choose not to review the contract? Okay, let's talk about that. Now, British computer game retailer, for example, this is also a very important things which we have to see as well as note. No, normally, how many of you, I mean, all of us uses internet applications, software, buying, etc. So all of you install applications in your mobile, in your computer, etc. So how many of you, in normal case, read all the license agreements and then you accept or reject? It's very rare that everybody reads. So, but some people read, of course, but most of the people never read. So this is why that means you're not actually reviewing your contract. So if you are not reviewing your contract, then is it binding? Now, definitely, if you say you have agreed, then you are agreed, and it is none of the companies matter that whether they are in good faith or bad faith. So we will see that. One another example which would be very interesting for all of you, that is a British computer game retail game station on April Fool's Day added this to term and terms and condition, that is the customer agrees to pay before buying online. All right, they have written everything proper. And you also have options, by the way. So by placing an order via this website, you agree to grant us a non-transferable option to claim for now and forevermore your immortal soul. This is what is they have done. Now, should we wish to exercise this option, you agree to surrender your immortal soul and any claim you may have on it within 5 working days of receiving written notification from gamestation.co.uk or one of its duly authorized minions. So if you, then you have options that A, do not believe you have an immortal soul, B, have already given it to another party, or C, do not wish to grant us such a license. Please click the link below to nullify this subclause and proceed with your transaction. So you have in that contract all the possibility that either you just leave it or still you can buy the things. But what happens, the result? 7,500 online shoppers unknowingly sold their souls in the game station. This is a Fox News, whether it is valid or not, but it is Fox News. So in that sense, people are not reviewing their contract. So the point is catchy, that is because it is of an April Fool Day, therefore they are not really going to claim your soul. So what if you sign a contract that was dramatically unfair on the other hand? So this is about the earlier one is actually still you had possibility to review a contract, but most of you haven't, or most of you never do that thing. So are you binding? Technically speaking, under the legal structure you are, but on the contrary, in that particular case, this is because of the April Fool, they immediately reviewed their things back, and they just, it is for understanding people's mentality. So that's it. So they just reversed everything. So that is fine, but on the contrary, things are going to be really bad. So what if you sign a contract that was remarkable? Yeah, let's move to the other question. So under bargaining theory, court should ask only whether a bargaining occurred, not whether it was fair. Okay, so this is what is under the bargaining theory everybody looks for. So whether you have done it properly. Now, the part of fairness and unfairness is not at all a concern of the court in that matter. So, for example, the hand vessel sideway, drinking and smoking example, right? But both common and civil law have doctrines for not enforcing overly one-sided contract. Now, unconsignability or lesion is one of the cases under this thing. That is, if it is one-sided, that you have no much option, then things are not going to be enforced in that sense or in that rigor. So unconsignability is one, or lesion is one of the case, that is absence of meaningful choice on the part of one party due to one-sided contract provisions. together with the terms which are so oppressive that no reasonable person could make them and no fair and honest person would accept them. Then, when the sum total of its provisions drive too hard a bargain for a court of conscience to assist. Now, terms which would shock the conscience of this court is also very important. The unconsignability example, let us talk about Williams versus Walker Thomas Furniture case. This is a CA District Court 1965. So, unconsignability has generally been recognized to include an absence of meaningful choice on the part of one of the parties together with contract terms which are unreasonably favorable to the other party. In many cases, the meaningfulness of the choice is negated by a gross inequality of bargaining power. Alright, so not normally monopoly cases, but situational monopolies are in that case involved. And think of Plouffe versus Putnam, our first example in that sense, sailboat in storm, not Microsoft. Then, so this is two important things, that is normal monopoly cases, but situational monopoly. Normal monopolies like sailboat examples. Situational monopoly, there is no normal monopoly there. Situationally, there is no other option, so you have only this person's yard, and therefore you just try to tie your boat. But unfortunately, there are natural monopolies like Microsoft, and also how do we do it? That is a very different question. So next we discuss about the remedies for breach of contract. Now, three broad type of remedy for breach of contract. Let us talk one by one. So party designed remedies, first one. So which is actually a remedy specified in the contract. So this is what is called a party specified remedy or party designed remedy, where both the party agrees upon conditions and remedies are evolved based on their own conditions. So there it is there. So the second kind is actually the court imposed damage, which is court may decide promisee entitled to do some level of damage or not. So that would be evaluated based on their own hearing and things like that, and then they decide. Then the last one is specific performance. Okay, this is very interesting part which somebody has to look for. It is forces breaching party to live up to contract. So this is what is specific performance. Specific performance means that you have to do the contract, whether you cannot is actually not at all a reason. You have to live up to the contract, otherwise you have to pay a huge damage. So expectation damages, that is compensate promisee for an amount he expected to benefit from performance. So you agree to buy an airplane, that example which we had talked about, airplane example, where you agreed to buy an airplane for 3.5 lakhs. You expected 5 lakhs, so your benefit is actually the expectation damage. If I breach, I owe you the benefit of 1.5 lakhs. So where positive damages make promise indifferent between performance and breach, where reliance damages reimburses promise for cost of any reliance investment made but not for additional surplus he expected to gain, and restore promise to level of well-being before he signed the contract. You contracted to buy the plane and built a hangar. So if I breach, I owe you what I spent, the hangar, nothing else. So this is what we have seen in the reliance damage. Then you have negative damage, undo the negative harms that occur. That is what is called the negative damage. Then there are other problems in the economics. Economists normally talked about is opportunity cost damage, which is give promisee benefit he would have gotten from his next best option, like the buyer or somebody who is. So make promisee indifferent between breach of the contract that was signed, the performance of the best alternative contract. So you value plane for 5 lakhs. So that context, you contract to buy an airplane from me 3.5. Someone else is actually selling similar plane at 4 lakhs. So that is 50. By the time I breach, that plane is no longer available. So I owe you 1 lakh in that sense. So the friends, the benefit you would have gotten from buying the other seller's plane. So in that sense, instead of 1.5 lakhs, what I give is actually 1 lakh. So there are so many different kinds of compensation in that sense. Expectation, reliance, opportunity, cost, damage, etc. So you agree to sell me a ticket to Wisconsin, Ohio, a state football game for $50. So the expectation damage, you owe me value game minus $50. If I pay scalper then $150, then expectation damage is actually $100. Reliance damage may be zero, or cost of whatever pre-game investment I made. When you agreed to sell me ticket, other ticket available is 70. So what was actually opportunity cost? The $80 I paid scalp 150 to get it, and I would have been 80 better off if I ignore your offer and paid someone else at $70. So now that is also makes all kind of the matrix of benefit, that is the damage which was being paid as well as your expectation on based on that difference. So ranking damage is something which is very interesting. All of expectation damage is 100, which is greater than or equal to opportunity cost damage, which is 80, and reliance damage is 15. So so this is actually going to give you kind of ranks where people interest lies on. That is, the normal case expectation damage is too high. So everybody wish to have an expectation damage when there is a breach. At the same time, the opportunity cost damage is actually even lesser than the expectation cost damage, and reliance damage obviously is much lesser than the opportunity cost damage, because it's only talked about the reliance. So that means we can have a grading of all this preference people may be having it. So contract which is greater than best alternative, which is great. So this is gives us a kind of proposition, that is expectation damage is actually a contract I sign, so I do have an expectation. Then best alternative is comes under the opportunity cost, and do nothing is actually reliance. So this is what is called the breach plus expectation, breach plus opportunity cost damage, and breach plus reliance damage. So it is quite interesting. Now we have a proposition like which one you always have a higher one. So this is what is actually in a nutshell which we can say about the ranking of this. So Hawkins versus McGee hairy hand case. Let us talk about another kind of problem which is may occur. That is, Hawkins had a scar on his hand. McGee promised a surgery to make the hand 100% perfect. Now surgery was a disaster, left the scar bigger and covered with hair. Okay, so that is going to have a kind of different points. That is, this is a perfect 100% perfect. If it is 100% wealth, then scarred kind of thing, then this is actually the kind of differences people may be having it. So your expectation damage would be in this case very high, hairy, then you have to have a very high expectation damage. Where if you have a reliance, then you have maybe you expect it, and so your reliance damage is this much. And the other things, then you have a very different one, opportunity cost. So this is how you can immediately draw under an economic analysis that in the two-dimensional vector space you have on the x-axis you have different things like hairy, scarred, next best doctor, 100% perfect kind of situation. So you have different ordering. At the same time, the different kinds of your wealth minimization or maximization, which is actually plotted in the y-axis. So in the expectation damage case, that is the highest cost, which is always goes on the other side, which is the 100% perfect case, right? So then you have this ranking of expectation damage, opportunity cost damage, and reliance damage, which has been given on this side. So you can look into the size and say that which one you like and what kind of investment we are going to have or contract we are going to enter into. That's about all this analysis and other court order remedies, which is second case which we have said the court can actually give things. So restitution and disgorgement is to the two things for court ordered remedies. Restitution is return of return money that was already received. This is what is called restitution. So if you paid some amount advanced, then that money has to be paid back. So this is what is called the restitution order. Disgorgement is give up wrongfully gained profit. For example, in that context, how much you got, that has to be given up to these people. This is what is called the disgorgement case. So it is quite often true with the contract that, for example, suppose two cases also, two case can equally applicable in the same contract. For example, if I enter into a contract to buy a house, say 40 lakhs rupees, then our contract has been done and I have paid 2 or 5 lakhs as an advance. Now after some point they were actually not proceeding with their contract, and then we found out that they were trying to actually not sell to me. They don't want to sell. And then I found out the reason, and then they were trying to actually sell it to somebody at a very high price, like say 15 lakhs or 45 lakhs. Now in this case there is two possibilities. If I sue in the court, two possibilities: one is restitution, the other one is disgorgement. The restitution case is okay, the 5 lakhs rupees I paid, I'll get back, that's it. So I don't gain anything, because during that period maybe I borrowed that money and I would have actually paid an interest in that sense. Even court never speaks about that. Still there may be a compensation, then that is only the compensation which is actually what I borrowed. So at the most what I get is actually the money which I paid. This comes under the restitution. But on the contrary, there is a disgorgement that talks about the gain which the other party. So now because of this price, they can surely show it to somebody who can actually buy the place. And now they are buying at a very high price. So the question is that which money I have to get back. The amount I paid or the profit. The money plus the profit. So the last point in that sense, the third remedy is called a specific performance. Even the court can talk about the specific performance case also. Now what is actually the court can say is that you have to sell. Okay. This is the third kind of thing which the court can order. Promisor is forced to honor the promise. Like civil law often ordered instead of money damage. So normally in the continental Europe and all, this is a common practice in the, especially under the civil law. That is, if you made a contract, you have to enforce the contract, or you have to honor the contract. So in one way it gives the clarity as well as the performance in its best form. So common law, money damage more common. Specific performance sometimes used when seller breach contract to sell a unique good. So this is the case in the common law. So like injunctive relief in that sense, it acts as an injunctive relief in a common law. So expectation damage versus specific. Now let's talk about the expectation, which is the highest damage, and the specific performance case. Okay, now you check. Now if we check with the PV House versus Garland Coal Mining Company's case, which we have already talked about. Okay, the Garland contracted to strip mine coals on PV's farm. All right. Now PV's house owned that farm, and Garland is try to strip mine coal. Okay. So contract specified Garland would restore property to original condition. What is the contract? Restore the property in an original condition. Garland did not. Why? Restoration would cost $29,000, but a diminution in value of farm was only $300. This is what is actually the argument of the Garland. Original jury awarded $5,000 in damage. Both parties appealed. Okay, the original case was actually said, okay, since you have only $300 diminution of value, so even the court given a damage of $500. In both the cases, they were actually sued they appealed basically. So Supreme Court reduced damage to 300. Why? At first sounds like a perfect example of efficient breach, but it is not. That is, performing last part of contract would cost $29,000. Benefit to PV House would be $300. That again, okay, in that case, that is, if you perform of $29,000, the benefit is ultimately $300. Though efficient to breach and pay expectation damage, which is what happened. But most coal mining contracts, standard per acre diminution payment is actually what is that $300. But not necessarily that is true. So PV House refused to sign contract unless it specifically promised the restorative work. Dissent is that the PV House entitled to specific performance. Why? Because that is the contract. Otherwise, why should they do it? So PV House seems to value condition of property much more highly than change in market value. So the market values in that sense normally never reflect of the reality of the people who own or possess or keep. This is also very important because of you may be having attachment towards a property, but other may not be seeing it. For example, if you have a property, maybe a valueless for the other person, but you may be having an attachment. Your father or grandfather or forefather or your mother or grandmother or great grandmother will be buried there. So you may be having an attachment that that land belongs, or there is a promise, as Amartya Sen said, in the deathbed promises. So if you make that, then things are going to be different completely. So why the restoration is also a question which is we have to keep in mind. So think about PV House in terms of penalty default, right? Now look at on the contrary, that is in the expectation damage case, normally what PV got is it's a paltry amount like $300, which is a market value of diminution. All right. Now, if you change the law, like penalty default, as we have pointed in the beginning, this is going to be completely different. That is, a contract promised restoration work didn't specify a remedy if it wasn't performed. So, which default rule works better? So, default rule allows Garland to breach and pay diminution fee, or default rule forcing Garland to perform restoration work. So in the paper which we mentioned, Ayers and Gardner, default rule should penalize the better informed party. So we had already seen this default rule per se is going to penalize the better informed party. That means if you are known, it is actually called the price of knowledge. So Garland routine signed contracts like these. PV houses were doing this for the first time in that sense. Garland routinely do because they are miners, they do keep do mining. So for them it is not a new thing and they are experienced. But at the same time, PV house not. They had given their land because they thought that actually it would be restored. So PV were doing this for the first time. Suppose if that is the case, then default rule allows government to pay diminishing fee. They have no reason to bring it up. PV house don't know about it. So default rule forces government to do cleanup. If that is inefficient, they could bring it up during negotiation. In that sense, that is, if 29,000 is too high for them, then they will be actually talks, the cleaning up process in the beginning itself. So otherwise they won't, because in this case specific performance would serve as a penalty default in that sense. That means they will be negotiating in the beginning and then they'll make a contract accordingly. So party designed remedies in that sense. Remedy for breach could be that is the first one which we talked about. That is actually something which we need to look into. The remedy for breach could be written directly into the contract. That is normally some obvious one. But common law code don't always enforce remedy terms. So why this is important? In the civil law it is most commonly used, and you have to, the party has all this kind of remedy. If it's been done, then this would be the case. But in the common law, you don't actually write all this kind in the contract per se. So contract only talks about the things. What you don't do on breach and all, there won't be any. It will be as and when it comes to the court, they will decide upon it. So this is a kind of standard format which normally adopts under the common law framework. So liquidated damage, that is the party specified damage that reasonably approximate actual harm done by breach. So then you have a penalty damage, as we have, that is damage greater than the actual harm done. So in civil law, court are generally willing to enforce penalty damage. This is very, very important. Whereas in the common law, court don't often do. Okay. So let us talk about penalty damage, because we will also talked about the civil law countries as well as. So PV House versus Garland Court. PV House only wanted farm strip mined if it would be restored to original condition. After, suppose coal extracted worth is 70,000. Now Garland paid 25,000 for rights to mine it. Restoration work would cost 30,000. Now diminishing value is 300. So liquidated damage would be 300. Suppose PV House got 40,000 of disutility from land being left in poor condition. Then what happens is the following: like PV House sign, don't sign. Then we have already seen the trust game, right? So if you apply that logic, what happens? PV House don't sign, both of them gains nothing. Okay, if they sign, they definitely restore property, then 25, then 50,000. They don't pay damage, then what happens? The 14,700, which is actually your diminishing value, and the other person is losing 14,700 rupees because they will get only 300 as a damage, and 44.7 thousand with Garland. So what is the best case for Garland? 44. So they will always go for, in the game, in the beginning itself, they will go for actually default, don't pay damage strategy, because that would be always better. For at the same time, if we look at for minus disutility, that is 14,700 disutility in the beginning. So which
and 0 on the other door if you lose nothing. So which one is your best preference strategy? You don't sign. So what would be ideally if you don't have trust in that context? Apply a simple trust game, you will immediately understand that there cannot be any sort of contract between PV House and Garland, because they know that there is a possibility of a breach. So if damage limited to liquidation damage, then that is the $300, then the contract will never even arise from a theoretical point of view. So PV House shouldn't believe restoration work will get done. So PV House better off refusing to sign. So even though mining and restoring Pareto dominates. So we know that the mining and restoring is actually in this case is a Pareto domination. Okay, where both party get better off, because 0 is less than 50,000. Where you have actually nobody is having a disutility, both gains. But that has not been actually happened because of this opportunistic behavior which people anticipate. So if penalty clause in contract were enforced, on the contrary, if we apply penalty default, the picture changes completely. That is, a contract, write a contract with the 40,000 penalty for leaving land unrestored. If you do that, then that is actually going to be having a positive effect. That is, Garland Call is going to actually gain. If they don't pay penalty, what happens is that they are, even after their court will enforce 40,000 and they will be left with only 5,000. So what they do is actually they will perform. They restore property as well as they gain profit. So still $15,000 they get out of this restoration work. Now restoration work would get done. So PV willing to sign. What happens? In both cases you gain, and the Pareto improvement is the case. So theoretically we can argue that when people ideally think in that sense. So but if we court won't enforce penalty damage, this won't be the case. So you should know that the penalty damage clause is not a very less likely thing. It is much better than the other things if this is the case. So whatever you can accomplish with penalty clause, you could also accomplish with performance bonus. So I agree to pay you 2 lakhs to get house built, but I want you to pay 50,000 penalty if it is late. Alternatively, I agree to pay 1.5 lakhs for house plus 50,000 performance bonus if it is completed on time. Either the way, you get 1.5 lakhs if houses is late. The house is late, then 2 lakh if on time. So courts generally enforce bonus clause, so no problem. So this is a kind of similarly PV house example. PV house get 25,000 for mining rights, 40,000 penalty if land is not restored. Equivalently get $65,000 for mining rights, pay 40,000 bonus if restoration is completed. But if intent of contract is too transparent, still might not be enforced in that case. So there are so many other dimensions in that. So effects of different remedies on this: a decision to perform or breach, decision to sign or non-sign, invest in performing, investment in reliance. You have different kinds of this possibility, and the remedy and breach in that sense we need to talk. So expectation damage and specific performance, the advantage and disadvantage. Let's talk about it. So if I get, you get, and total is this thing. So which one is cost low minus perform? So which would be very high in that sense. Cost high, reach that is minus. So on the left hand side you have expectation damage example. So in the specific performance, if you analyze, same cost low minus perform 2.5 lakhs, cost high performs. So you don't cost high, renegotiate, then you will talk about it. And then you have this thing that is -4 +4, so 0, 0. Okay, so this is the case with the negotiate and when you have, then we apply our old theoretical, the earlier theoretical proposition that when transaction costs low, either lead to efficient breach, but seller prefer weaker remedy. That is this first one, expectation damage. So if you have a transaction which is very high, SP leads to inefficient performance. That is, the specific performance leads to inefficient performance. So what is there is also a paradox of compensation in that sense. That is, expectation damage include benefit from a reliance, that is efficient breach, efficient investment performance, and over reliance is the result. Whereas expectation damage exclude benefit from reliance investment, then what happens? Inefficient breach, under investment in performance, and efficient reliance. So is there a way to get efficient behavior by both parties? Well, this is a very important question we have to. But at the same time, we have already saw one possible solution, that is, have expectation damage include benefit from reliance, but only up to the efficient level of reliance, not beyond. Okay, so you have to make a point that it is efficient level of reliance. That is, have damage reward efficient reliance investment, but not over reliance in that sense. A promisee has no incentive to over rely because efficient rely, then they will be efficiently rely. If they rely efficient level, they rely on efficient level, and a promiser still bear full cost of breach, then efficient performance is their intent. What is the problem with this? Theoretically it's all, or conceptually it is very clear about all of this, but in reality things are not as clear as we think. So this requires court to calculate. Now from the point of view of the court, this requires a huge calculation. That is, calculate the efficient level of reliance after the fact. At the same time, you have other problems also. So another clever but unrealistic solution, like the problem, damages promisor pay should include gain from reliance if you want to get efficient performance. That is, damages promisee receives should exclude gain from reliance if we want to get efficient reliance. So this is very interesting way of understanding. So solution, make damage promisor pays different from damage promisee receives. So you make a very different thing. So how do we do this? Again, need a third party. So you're trying to bring a third party in the picture. That's it. So these are actually kind of different possibilities with the negotiation and renegotiation of the enforceability of contract and the problem of contract. Now the last point which we like to talk is anti-insurance portions of the contract. That is, you a promisee and I am a promiser of a bogus deal. That is, if you rely and I breach, I pay both value of promise with reliance, that is the airplane plus hangar. Bob pays you value of promise without reliance, airplane alone. Bob keeps the difference. Alright, so this is a kind of. So you receive damages without benefit from reliance. I pay damage with benefit. So this is a kind of situation. So offer the deal to two people, make them pay up front for it. So that's it for contract, and purpose of this lecture is all brief. Lecture is on encourage cooperation, encourage efficient disclosure of information, secure optimal commitment to performance, secure efficient reliance, provide efficient default rule and regulations, foster enduring relationship between the parties. So these are actually what the context which we discussed in this thing, and how we achieve it, and which one is the best thing, etc. So thank you very much for listening to this lecture, and I hope all of you enjoyed it. Thank you once again.